Welcome. My name is George Griziotis and I'm from ACROGON IP. I have some information that you probably would like to know, and you want to know pretty well the details before you embark on any journey into IP. And one of those questions that we're often asked is, can I disclose my idea or my invention or offer to sell my idea or invention before I seek patent protection? Well, generally speaking, we don't recommend any disclosure or sale of an invention or a design prior to filing of a patent or a design application. And the reason for that is that you could quite well be shooting yourself in the foot by doing so. And there are some grace provisions which might come into play to save you, but we don't recommend you rely on those. In Australia and New Zealand, and in many other jurisdictions around the world, prior public disclosure and prior use and prior sale all constitute barriers to the granting of a valid patent or the granting of a valid design. And so our take-home message for all clients and for those curious about embarking on this IP protection journey is not to disclose your invention or your design unless you've filed a patent application or a design application. That's where we can help you at ACROGON IP. Now, others ask, what kind of information do I, as a patent attorney or any of our other patent attorneys, need in order to start this journey? Is it a lot? What kind of technical detail is it? Am I going to be taking a long time to prepare the information? Well, we do need a brief. We do need a significant amount of information that will allow us to understand what your invention is or your design, and in the case of trademarks, what that trademark is. So a depiction of the trademark, for example, is ideal. These sorts of details are the sorts of things we will be discussing with you at any meeting, and it's at that meeting where you'll fully understand the breadth and the importance of providing the necessary information. You might also ask, this all takes time, but it must come at some cost. And yes, registering your IP does cost money, both in attorney fees and patent office fees, as well as associates fees where we're required to utilise the services of associates in, for example, other jurisdictions or for preparing certain documents or drawings. But the range of intellectual property that's available is so diverse that you can't provide one quote for every kind of intellectual property that's able to be registered. And so with things like patents, even the cost with patents can vary over a large degree, depending on the subject matter and the time and the effort that's involved. We recommend that you speak to us, and we can give you a tailored approach to dealing with your idea and seeking protection for it. And once we understand fully the nature of your idea, we can provide you with a quote of the costs and the path through the process, and where at the different stages in that process the costs will be incurred. And this can all be put down and on paper and provided to you for review. Now, some clients go to the trouble of trying to file their own patent or trademark applications and occasional design applications, but we don't recommend you do that. But if you do, and you come up with some problems or there's an obstacle along the way, then we would be happy to help and provide you with an opinion and some guidance on what you could do to remove the problem, solve it, and move forward. So I just hope that these few bits of advice have been helpful. and I look forward to speaking to you again in another video in the not too far distant future. Thank you.